Well, good afternoon, everyone, and thank you for joining us today on this day after our wonderful long weekend. I hope everyone had a lovely celebration, be it Easter, Passover, Ramadan. We hope you spent time well-deserved with family and friends. My name is Mary Shakuri, and I'm with Elder Abuse Prevention Ontario, and we are very honored today to have our guest speaker, Helen Button, from the law firm today, who will be taking us through from Gunn and Associates on fulfilling an older adult's best wishes and really diving into and understanding the roles and obligations of a power of attorney. As always, I'd like to begin with our land acknowledgement. We acknowledge that we gather on the traditional territory of a number of First Nations and acknowledge their stewardship of this land throughout the ages. We seek a new relationship with the original peoples of this land, one that is based in honor and deep respect. So a little bit about our webinar housekeeping, if you are joining us for the first time. All our attendees are muted during the webinar, so you don't have to worry about muting and unmuting, as well as our speakers will be visible during the presentation, and you will be able to adjust the view on the top of the grid of where the speakers are located, so you can adjust to what is more a comfortable viewing for you. Our ASL interpreters are visible during the entire webinar, and you can view them by clicking on the gallery view as well. And as I let you know, you can adjust the speakers by dragging the line between the image frame from the slides, and that way you can either make the images larger or smaller for what is most comfortable for your viewing pleasure. Our chat box, of course, is always open during the webinar, and we ask you and invite you to post comments during the session. Now for Q&A, please put your questions in the question box, and we will have time at the end of the webinar, and Helen will be more than happy to help answer the questions that come through the Q&A box. The webinar is being recorded, and this will be posted on the Elder Abuse Prevention Ontario website within 48 hours. And of course, at the end of the webinar, you will receive an evaluation link. I just ask you, please, just to take a few moments. Your feedback is essential for helping provide information to us here at Elder Abuse Prevention Ontario for your feedback, comments, and future webinars and information. So if you could just take a moment to fill that out, it's greatly appreciated. And regarding, of course, privacy and confidentiality, we appreciate that personal circumstances or issues may arise during the webinar. However, we ask that you keep, the commitment in privacy and confidentiality when addressing comments and questions in the comment and Q&A box. For any personal situations that perhaps you'd like to discuss afterwards, you can reach out to us at Elder Abuse Prevention Ontario, and one of our consultants will be more than happy to speak to you about that. So a little bit about our organization for those of us who may be joining us for the first time. Elder Abuse Prevention Ontario mandate and mission across Ontario is to have our province free from elder abuse, where our seniors have a strong voice and feel respected and safe. And we achieve these missions in 3 different pillars: by raising public awareness and education through a province-wide multimedia public education platform, much like we are doing today. We work very closely with frontline staff in various sectors in training those working directly with seniors to help enhance their knowledge and skills to recognize and be able to respond to elder abuse, and working with our elder abuse networks, action tables, and committees right across the province from north to south, east to west, to continue to strengthen the collaboration of our local networks across the province. It gives me great pleasure to now introduce our guest speaker for today, Helen Button. Helen grew up in rural southwestern Ontario and worked in public relations before becoming a lawyer. She earned her JD from Western Law in 2013. And after being called to the bar in 2014, Helen practiced law in a firm in Simcoe County in Ontario before joining Gunn and Associates. And she is an associate as of January of 2020. So congratulations on becoming an associate, Helen. She assists in clients in a range of practices involving estate planning, administration, powers of attorney, and serving for guardianships that has a particular interest for serving seniors and their families. I also work with Helen as she is also a member of the Elgin Elder Abuse Network and is a very active member there and very dedicated in her community in preventing and combating elder abuse. So I was very honored when I had reached out and she was kind enough to say she would be able to do a webinar for us today. So without further ado, I will hand over to our guest speaker and we'll enjoy all the information she will provide us today. Thank you so much.
Wonderful. Thank you, Mary. So as Mary said, I'm a lawyer. I practice in St. Thomas, Ontario at a firm called Gunn & Associates. I do a lot of work with seniors, with powers of attorney, and sometimes with guardianships as well. So my talk today is on both of those things, powers of attorney and guardianship. I'm going to provide a bit of a general overview on what those are, how they work, but then move on more to focus on what the obligations are of the person who acts in the role of power of attorney, and avoiding conflicts that can arise, whether that's planning for them and trying to avoid them or dealing with them if they do arise. And of course, happy to answer lots of questions at the end if those come up. So Mary, I'll go to the next slide, please. Okay, so first question is, what is a power of attorney? I often hear from clients who are a little bit unclear about what it is. Probably a lot of us listening today know, but it's a legal document that gives another person or multiple people authority to make decisions on behalf of the grantor. And the grantor is the legal term that we use for the person who makes the power of attorney. It's not a will, so it doesn't deal with assets after death, and powers of attorney become useless upon the death of the grantor. It's not an advance directive or care plan, so usually the power of attorney is not where you would put really specific wishes for care. There are two types of powers of attorney in Ontario. There's a power of attorney for personal care and a power of attorney for property. So your personal care would cover your medical, safety, hygiene decisions, things like that. And your power of attorney for property in the broad sense of basically financial decision making. Prior to, I think it was 1992, there was one sort of general power of attorney, and we now have these two separate documents. So next slide. Who can make a power of attorney? You have to be over 18. You have to be capable, and I'll talk a little bit more about what exactly that means in different contexts later on. And the power of attorney document has to be properly signed, dated, and witnessed. So next. And who can act as a power of attorney? There aren't any special qualifications, but people often have some uncertainty about who best to appoint. Some things that should be considered: where does the attorney live? Good idea to have them close if you can. Are they in good health? What's their age? Are they likely to be around to be helping for a long period of time? Are they good at making the kinds of decisions that will need to be made? And then on the topic of avoiding conflict if possible, if you're naming multiple attorneys, think about whether they get along. A lot of clients have optimism that if they name all of their children, the children are going to do fine together. But if they stop and think about it, realize that that might not be the case, or practically it may not work. If you're naming 3 people who live in very different places and have very different schedules, that can be difficult. So giving some thought to avoidance of difficulty or conflict if you're naming multiple attorneys is a good idea. So next. So looking first at the power of attorney for personal care. Personal care decisions that can be made by the attorney for personal care include decisions about healthcare, nutrition, shelter, clothing, hygiene, safety, consent or refusal to consent to treatment, and continuing or not continuing measures to prolong life. Those two at the end are the big ones that people often think about when they're thinking about preparing a power of attorney for personal care. But it can also be a lot of day-to-day decisions and tasks, like making sure the person has clothes that fit them properly and are appropriate for the time of year, making sure that their hygiene is taken care of. Could be daily things like making sure they get their haircuts regularly that they need, all of that kind of stuff. So it's big and small decisions. Again, the power of attorney terminates on the death of the grantor. So I sometimes see some confusion and occasionally some conflict over who has authority to make decisions about a person after death, when the person who's been acting as the power of attorney is different from the person who might be the executor named in the will. And it's important to know that that power of attorney becomes void on the death of the grantor and can't be used to make any decisions on the individual's behalf anymore. And it's activated. This is a little bit different from the power of attorney for property, which I'll talk about next. The power of attorney for personal care is activated when the grantor becomes incapable. So as long as the grantor is capable of understanding and communicating decisions about personal care, they are the only one who gets to do that. And only when they lose that capacity does the attorney have the authority to step in. That's not always really black and white, as you can imagine. We'll talk a little bit about how that determination can be made, but that is legally the way that it works. So on the next slide, we have how is that determination made? Who decides if a grantor is incapable of making personal care decisions? So what the law says is that a person is incapable of personal care decisions if they are unable to understand information relevant to the decision or can't appreciate the consequences of a certain decision. In a lot of cases, it's, if things are working as they should, it's often sort of a gradual process. Maybe mom or dad is kind of clearly losing the ability to make those decisions. The person they've appointed, son or daughter, maybe as their attorney, starts to get more involved and steps in, and it sort of happens naturally, and it's all good. Sometimes though, capacity can be uncertain. So if you are acting as or appointed as an attorney for personal care and you notice that the individual is making some decisions that you don't think are in their best interests, but the individual might insist that they're capable of those decisions, a capacity assessment might be necessary to determine whether they are in fact capable. A capable person is allowed to make decisions that aren't great for themselves. And just because maybe everybody might think that the decision isn't the ideal decision, if they're considered to be capable, they're able to make that decision. And so sometimes it becomes necessary to get a more formal determination from a capacity assessor as to whether the person is capable. That's not always possible to do on a voluntary basis. In some extreme situations, it's necessary to seek the court's assistance to order a capacity assessment. The court is really tends to be quite reluctant to do that against someone's wishes, and that can become, as you can imagine, quite a complex proceeding. But that is a possibility if other options are not working. Okay, next slide. And in terms of making a power of attorney for personal care, so the Substitute Decisions Act says that in order to be capable of granting the power of attorney, the person must have the ability to understand whether the proposed attorney, so that's the person they'd be appointing, has a genuine concern for their welfare. And they must appreciate that the person may need to make decisions on their behalf. So it's there's different criteria for capacity for different things. So for making the power of attorney for personal care, that's different from what's required for making a power of attorney for property, which is a little bit different from what's required for making a will. And if a lawyer is preparing the power of attorney document for the person, they should have those criteria in mind and make sure that they are satisfied that the person has that capacity. So next, what are the duties of an attorney for personal care. There are lots of them. Among other duties, they must maintain records of decisions made on behalf of the grantor, facilitate contact between the grantor and supportive relatives and friends. This is an important one, and it's one that's often neglected. So I am frequently contacted by people looking for help because the attorney is not facilitating visits for mom and dad with other children, or they feel that the attorney is preventing access by other family members or other people who are concerned about the older individual. Sometimes it may be that the attorney totally has the best interests of the individual at heart, isn't aware that that's an obligation that they have to facilitate that contact. Sometimes there are greater risks. Sometimes an attorney is abusing the authority that's given to them by the power of attorney document, and it's necessary to do more in order to sort that out. But that's an important obligation that an attorney has to make sure that that contact can still happen. The attorney also has to act according to the wishes of the grantor if they were expressed while capable. So if while capable, the grantor said, if this happens, this is what I would want done, this is what I would want the decisions made for me to be, then the attorney needs to bear those in mind and act according to them if possible. Of course, act only in the best interests of the grantor. That's the ultimate duty there. Obtain independent legal advice when necessary, and keep information confidential, among other obligations. Okay, next, the power of attorney for property. So again, this is sort of the second of the two documents. A grantor can appoint, again, one person or multiple people to act together as attorneys for property. In Ontario, if you go and have a lawyer prepare a power of attorney for property, you will usually get a continuing power of attorney for property, which is a little bit different than the way the personal care power of attorney works. So the word continuing is important. Power of attorney for property is activated when signed and does not depend on the capacity of the grantor. That's because sometimes people who are capable may want the power of attorney to be able to act for them. So it may be that they spend 6 months of the year in Florida and someone needs to be able to manage their affairs in Ontario. It used to be a little more difficult. Now we have so many remote options, but that used to be a little more common. But it also may be that physically the person is not able to attend to various obligations relating to their finances. So maybe they find it really hard to get to the bank, even though cognitively they retain the capacity to make decisions about their property. If a person becomes incapable of managing property, no one automatically has a right to step in to make decisions for them. So that's why it's particularly important to have that power of attorney document. The Healthcare Consent Act provides for some decision making by next of kin for medical decisions, for example. There isn't really anything like that for property. So that is where you sometimes will see a person who unexpectedly becomes incapacitated, doesn't have a power of attorney. Can be very difficult to get things done, like making sure mortgage payments are made, making sure tax returns are filed, things like that. Next, so what kinds of decisions can an attorney for property make? Basically, they can do anything that the individual grantor could do with his or her property except make a will. It's really the only thing that a power of attorney can't do. I have had people call and say, I want to make a new will for my mom, or I want to make a new will for my dad. I have to say, sorry, you can't do that. But just about everything else, the attorney can do on behalf of the person. So that can include daily banking and bill paying, dealing with investments, protecting or dealing with the person's personal belongings, attending to payment of long-term care fees. Selling a home is a major transaction that a power of attorney often has to do. Buying goods and services, starting or defending lawsuits, or collecting debts. Basically anything financial that the individual could do. So the next slide, who decides if the grantor is incapable of managing property? So when does the attorney really take over? So the law says that a person is incapable of managing property if he or she is not able to understand information that's relevant to making the decision, or appreciate the consequences of the decision. Again, usually it's not a formal process, and often if things are going the way you would hope they would, it's sort of a gradual, you know, if children are the attorneys for mom and dad, they may notice that mom and dad are needing more help with financial decisions, maybe becoming vulnerable to scam calls, things like that. I hear a lot of from my clients, and begin to get more involved with the finances and eventually take over. That's often the way it works. Again, though, if capacity is uncertain, a capacity assessment may be necessary. So again, sometimes we see the appointed attorney thinking, this person is making decisions that I don't think are great, but they're telling me they're fine. I'm not sure if I have the authority to step in and make decisions over their opposition or without them being involved. And then hopefully, you know, voluntarily a capacity assessment might be the thing to do. Or again, in some of those extraordinary circumstances, it can be necessary to seek the court's assistance to get some clarity on whether the person is in fact capable and whether it's time for the attorney to really take over. Again, if the person is found to be capable and they're making decisions that aren't great, that's their right to do that. But it's important to answer that question in those circumstances. What level of mental capacity is needed to make a power of attorney for property? So again, this is what a lawyer drafting a power of attorney for property should have in mind when they're talking to their client. So they need to, and this, as you can see, just looking at it, this is a higher standard than the level of capacity required to grant a power of attorney for personal care. So the person must know what kind of property he or she has and its approximate value, be aware of obligations owed to dependents. This is an important one because an attorney will have to also become aware of those and continue payments to people who are dependents of the individual. Understand what authority the attorney will have to make decisions on their behalf. Know that the attorney must account for his or her dealings with the person's property. The person must know that he or she may, if capable, revoke the power of attorney. Appreciate the risk that unless the attorney manages the property responsibly, its value could decline. And again, appreciate the risk that the attorney could misuse the authority given to him or her by the power of attorney document. So it's really about having a good grasp of what the individual's assets and debts are, and then having an understanding of the risk that is inherent in appointing someone to deal with those things. The next slide, what are the duties of an attorney for property? I think it's very important for an attorney to make sure that they understand these before they start to act, and to get legal advice if necessary. I really think that can be important. Duties include careful and accurate record keeping is a big one, and one that unfortunately often is not done to the standard that it should be done. I'll talk a little bit more about that in a minute. Avoiding conflicts of interest. So the attorney should not be dealing with the individual's property in such a way as to benefit themselves at all. Make expenditures that ensure the grantor meets their legal obligations. So that's again determining if they have payments to dependents, for example, payment of debts, and making sure those are met so that the grantor doesn't get into any trouble by missing any of those. Keeping the person's information confidential and obtaining legal advice where necessary. In some circumstances, an attorney will claim compensation for their work. Common law in Ontario has a structure for claiming of compensation. That's another reason why record keeping is important. Sometimes we see, often it will be after the grantor has died. The attorney may present a claim for compensation from the estate. It's much clearer to deal with that if there's a record of all of the work that they did to show this is what my compensation claim is based on. So the next one, potential sources of conflict that I see. This is kind of based on my practice and what I see most in hearing from both people who are planning to make a power of attorney or have made a power of attorney and people who are acting as attorneys. I also hear a lot from people who are not acting as attorneys but may have siblings who are appointed to that role, for example, and are concerned. So disagreements over living situations, unfortunately, I see quite a bit. And that I think can be an area where individuals can be vulnerable to abuse, and where it's really important to kind of have your feelers up and to be particularly careful. But sometimes you will see, unfortunately, an attorney misusing a power of attorney, and as I think I said before, restricting access to the older individual by other family members, keeping them at home with them. That's very concerning. Disagreements between co-attorneys is pretty common too, unfortunately. That's something that sometimes we can address in advance. If we're appointing multiple people and we know that there is a risk that they might have trouble getting along, we can do things like a tiebreaker clause in the power of attorney document. Or we can say, in the event that they disagree, I want them to consult with this person. Or if there are more than two attorneys, we can have a tiebreaker. We can do a majority rule. So sometimes that can be addressed in order to prevent there being any real hurdles that would delay decision making. Conflicts of interest, we see, unfortunately, quite a bit, or at least suspicion of conflicts of interest. So sometimes we will have people who are concerned that an attorney has done things that would benefit themselves. Sometimes we see people who want to do things that would benefit themselves, and we say absolutely not. But the most frequent one that people have concerns over is transfer of real estate to the attorney by the attorney for less than fair market value. Obviously is absolutely a no-go, but is something that sometimes people think they might be able to do, or other people are concerned has been done. And then failure to keep records is one of the most common sources of conflict with respect to powers of attorney that I see. I regularly have people contacting me concerned because often it doesn't come up until later, after the grantor has died and the beneficiaries receive information about what's in the estate, and they go, wait a minute, I thought there was more here. Or I was expecting, I thought the house went for more than that. What happened to all of it? And then we will turn to the attorney and say, okay, where are the records that you kept? And they may not have any, or they may have very sort of surface records that are not complete to tell us what the whole story was. So it's really, really important that attorneys keep those careful records. It's an obligation. You must keep them. You must account to the individual, so the grantor as well, but also ultimately to the beneficiaries of the grantor's estate. So that's a huge source of conflict, a big source of estate litigation that can be avoided by keeping proper records. Next slide, just a few final points before we talk about guardianship. There are different ways of appointing multiple powers of attorney. So you can have, so again, you don't have to have the same individuals as power of attorney for personal care and power of attorney for property. People might choose the individuals that they know who are best suited to those roles. Sometimes for parents, it's a way of including all children if there are lots of children, but not necessarily giving everybody the same role. And then you can also have your attorneys work together, and you can appoint them jointly or jointly and severally. So if you appoint multiple attorneys jointly, that means that every decision must be made together. And if there are 3 of them, they've all got to be involved in each decision. Jointly and severally means that while they all have the same authority and the same right to be involved in any decisions and right to know exactly what's going on with either the personal care or the property decision making, if one is not available, the other can still get things done. So when I talk to clients about how they want to set up their power of attorney documents, it's really weighing that flexibility with having that extra trust built in of having always multiple people needing to be always involved, or having the flexibility of not having to get together for every single decision. So that's a personal decision, but something that, again, can help us avoid conflict down the road if we think carefully about how best to do it. Revoking a power of attorney. So as long as the grantor is capable, they can always revoke their power of attorney, whether they do a new one or they can just simply revoke it in writing if they become uncomfortable about the person they've named. Always a good idea, of course, to let the attorney know. If I'm doing it for the person, then we would write to them and provide them a copy of the revocation and make sure they are aware that they no longer have authority to act under the power of attorney. On the flip side, an attorney can also resign. So they can say, I'm not up to this, or, you know, I don't think I can manage working with my co-attorney, and they can resign. So it's not a something that forces you to act. That being said, if you've been acting as an attorney and you've started, you still have to meet your obligations with what you've done. Okay, so I want to move on, though, to use the rest of the session to talk about what happens if an individual becomes incapable and has not made a power of attorney. And that may be, for some people, it's because they have never been capable of making a power of attorney. So I often help parents of adults with disabilities who would not have had the capacity to make a power of attorney at any time. But it could also be a person who is aging, maybe developing some cognitive issues, loses their capacity that they once had, and has never gotten around to making a power of attorney. And I often have people ask me, do I have to make one now while I'm young? I don't need one right now. And you don't have to, but the problem is that once you lose your capacity to make one, it's too late. And then your only option is something quite a bit more onerous, the guardianship, which I'll talk about. So when a person becomes incapable, does not have a power of attorney, a family member or friend can apply to be appointed a guardian of property and or a guardian of the person. That's a court application, and I'll talk about the process. If no one else is able to do that or suitable, sometimes the provincial office of the public guardian and trustee will take on that role. Typically, that's only as a matter of last resort, but that's something that can happen. It can be a time-consuming and expensive process. And also the courts are reluctant to appoint a guardian if a less restrictive alternative is available. So I'll talk a little bit about some of the findings that a court must make in order to appoint a guardian. But basically, it's a much more sort of blanket solution than what you get with your power of attorney. The authority granted to the guardian is significant, and the losses or what's given up by the individual who is incapable is also quite significant. So next slide. What is guardianship? So as I said, there are the two. There's guardian of the person, which is sort of vaguely equivalent to your personal care power of attorney, or you can have a guardian of property. Again, vaguely equivalent to the power of attorney for property. They're governed by the Substitute Decisions Act in Ontario, and they're appointed by the Ontario Superior Court of Justice. Appointment of an attorney requires an application to the court. And it's usually something that is brought by, or by its nature, it's something that is brought by someone other than the individual who is alleged to be incapable. When is it necessary? The next slide. So as I said, if the individual does not have powers of attorney for whatever reason, becomes incapable and requires a substitute decision maker to make their decisions for them. Could also be, though, if they have a power of attorney, but the attorney resigns, is deceased, or becomes incapable themselves, somebody may need to be appointed to take over. And if there's no backup person named in the power of attorney, then guardianship might be the only option. Or if the named attorney is removed by the court. So sometimes if some of those conflicts arise with a power of attorney and they are not resolvable, sometimes another individual, often it will be, you know, another child of the incapable individual who will bring a court application to remove the person who is acting as a power of attorney. And again, if there's no backup named, part of that application would be an application to appoint someone else as a guardian to be able to continue making decisions on behalf of the incapable person. Next slide. Some differences. So as I said, powers of attorney are given by the grantor. So the big thing about a power of attorney is you are making a choice about the person you're appointing. So if it's an elderly person, they are picking the people who will be making decisions for them. Whereas guardianship is ordered by the court. It's usually upon application by the person who wants to be appointed guardian. So it removes that element of choice from the older individual. It's a much more involved process. The last one that I completed took about a year start to finish. And I'll talk more about what the process involved, but it's not, you know, a power of attorney. Someone comes to my office, gives me instructions. I can prepare one pretty quickly. Maybe they come back and sign it a week later. It's done. This is quite a different thing. Another thing that gives people some pause and should give some pause is that it can't be done without a really significant loss of privacy for the individual. So the application process requires notice to be given to certain family members, the public guardian and trustee's office. It also requires disclosure of a significant volume of financial and personal information that then becomes public record because it's part of a court proceeding. So there's a lot of privacy that's given up by the individual through that process. And as I said, courts take the applications extremely seriously. They will not appoint a guardian if there's an alternative that's less restrictive of the person's rights. And they will, every judge that I've dealt with on a guardianship application has reviewed our materials extremely thoroughly, taken the matter very, very seriously, and only will make the order as kind of the last resort if it's clear that it's the right thing to do. So the application process, in order to have an appointment to a guardian, the court order has to make a finding that the person is incapable. So when you are applying for guardianship, the order that you'd be seeking, if you're doing both personal care and property, it would be sort of in two sections. And the beginning of the order regarding personal care would say, this individual is incapable of personal care and requires a substitute decision maker to be appointed to make decisions for them in that regard. And then same thing with property. This person is incapable of managing property. Typically, this is proven by way of a formal capacity assessment that an assessor would perform, provide a report. It should be have been done within the last 6 months when you're bringing the application. But other evidence can be provided as well. So there is affidavit evidence that accompanies a guardianship application. And usually it will provide, can provide medical history, can provide kind of the background if a person has been through, some cognitive decline, explain that. So that's where that evidence comes from to help the court to make that finding that the person is incapable. And then the application to the court includes a management plan for an application to be a guardian of property and a guardianship plan for an application to be a guardian of the person. These are documents that the provincial government prepares. They are extremely thorough plans of what the guardian intends to do if they are appointed. And they have to include, so the management plan about property includes a list of the person's assets, a list of their sort of typical expenditures, and then a very detailed plan of how the attorney intends, or the guardian intends to manage that person's property for their benefit. And then the guardianship plan, again, a very detailed setting out of the individual's personal and medical information, also information about their social life, their recreation, their employment, if they have employment. And then again, a detailed plan about how the guardian intends to foster their well-being in that regard. So that's part of that sort of loss of privacy for the individual, because that all becomes part of that court application. And it's hard work and should be taken seriously by the applicant, because they really want to see that you've thought very hard about how you're going to do this. And often I find, if I have clients who think they want to be guardians and they start going through that, they think, wow, this is a big deal and it's very serious. And then in the application, the prospective guardian must justify both the need for a guardian and why they are the right person. So you need to be able to say both, mom is incapable, needs help with all of these decisions, and here's why I am the person to provide that help. Similar to power of attorney, you can appoint multiple guardians. So if you might have, I've done it more when it's an adult child of parents who are applying, we'll put both of the parents. But you can also have, two children or niece and nephew or whatever who apply to be co-guardians. Next, so notice requirements. This is another fact of the guardianship application that gives people pause. So unlike with a power of attorney, if you are applying to be appointed someone's guardian, you have to notify various people of your application and give them an opportunity to respond. So one is the Public Guardian and Trustee's Office. They will review the application and respond to it. Sometimes they will request more information. Sometimes they will request that what's called a Section 3 counsel. So that's a lawyer who would act on behalf of the incapable person and make sure that their interests are protected in the process. Sometimes the PGT will request that counsel be appointed to speak with and represent the individual. If there are any existing attorneys or guardians that you're seeking to remove, they would obviously have to be notified, but also family members of the alleged incapable person. So a spouse or partner, children who are at least 18, parents, brothers and sisters. So as you can imagine, that's hard to stomach for some people, especially, we have situations sometimes where it's separated parents of a disabled child, and one who has been involved and one who has not, realizing, oh, I have to notify the other one. But it can also be, children of elderly parents, wait, I have to tell my siblings. And you can see the reason for it. It's all, in order to protect people, but it can be a trigger for opposition to the guardianship application, certainly. And that can be sometimes where conflict comes out of, because the people who are notified have an opportunity to respond, and they may respond and oppose the application. They may respond and say, well, wait a minute, I should be, or at least you should not be the guardian. And so that's a real significant difference from the power of attorney process. And it's one that gives people a lot of pause when they're at the outset of that process, thinking about, do they really want to do it and how is it likely to go? So again, problems that can arise with guardianship applications, opposition by family members is a big one. A contested guardianship application can become a really complex legal proceeding. You can end up, so the last one I did that was contested, we ended up having to get, evidence from all sorts of other sources as to why the proposed guardian was in fact the right person to become the guardian, and the person opposing it was not. As you can imagine, it can be quite distressing for families going through that. A lot of feeling that, we're airing our dirty laundry, we're having to justify ourselves when we feel we shouldn't be. I often have clients feel a bit resentful of some of the process, feel really scrutinized by it. And of course, they understand that the whole thing is about protecting the individual who is alleged to be incapable, but it's not a fun process to go through. You can also, though, have opposition by the alleged incapable person. And that's similar to where we talked about an individual who may be insisting, when there's a power of attorney, that they are fine to keep making their own decisions. And again, that may be where you, as part of the guardianship application, you ask the court to order a capacity assessment if the individual won't voluntarily go through that process. And again, that can be pretty distressing as well, as you can imagine. Usually then, if that was what was happening, you would get that Section 3 counsel appointed to act only on behalf of the individual and to try to make sure that their interests are addressed and their needs are met through the process. So next, duties of a guardian of the person. Long list. It's even longer than this, really, but these are some of the most important ones. So some of them are quite similar to the attorney's duties. Decision-making about healthcare, nutrition, etc. Also decision-making about employment, education, training, clothing, recreation, social services, and personal matters. So the attorney or the guardian really has to be facilitating that person's well-being in all of those areas. Encouraging participation by the person in decision-making. So to the extent that they're able to, they should be involved in decisions about themselves. Acting in accordance with their wishes and always their best interests. Keeping records of decisions that are made, facilitating contact again between supportive relatives and friends with the individual. Sometimes it can be exercising powers of custody over the person, especially if safety is a concern. Acting as a litigation guardian, so if the person is involved in court process, that guardian would be standing in their stead through the process. Settling claims or commencing claims on their behalf. And there's a duty to be aware of the law around guardianship and all of the obligations that the guardian will have. On to duties of a guardian for property. So acting in accordance with that management plan, giving information to the incapable individual about what the guardian is doing and what their powers are. Again, encouraging participation by the individual, keeping detailed records and accounts, extremely important, passing accounts as required. This is a formal court process that is sometimes required by the public guardian's office as a term of the court order, that the guardian will pass their accounts after, for example, 2 years or 3 years. And that's an extremely detailed accounting of all of the ins and outs, all of the financial activity that the guardian has undertaken on behalf of the incapable person. So that means you keep your receipt from, it's important, you keep everything so that you're able to do that passing of accounts and show what you've been up to for the last, couple of years since the order was made. Acting in the best interest of the person with a view always to maximizing quality of life. Making expenditures that are necessary for that person's quality of life and for their dependents. So again, keeping up with any expenditures that they may be legally required to make. Acting with honesty and integrity in all of their duties. And then a guardian who receives compensation must exercise the degree of care, diligence, and skill of a person who is in the business of managing property for others. So it's a quite high threshold if you are going to claim compensation for your work as guardian. Just a short note at the end before questions on costs and time. So like any court proceeding, a guardianship application can be lengthy and expensive. Costs are often paid out of the incapable person's property, but that's not guaranteed. So there is no guarantee at the beginning of the process that all of the fees and costs associated with the process are going to be covered. And there could be personal costs for the guardian and certainly if the guardian is not successful, if the court says this was not an appropriate application to be made, then you would expect that you are paying your own costs. Sometimes there are bonding requirements. So sometimes if the court is concerned, especially if an individual has significant assets, the court may require that the applicant take out a bond as security for those assets so that there is some protection for them. And so that's another cost. And then costs, of course, can be increased by added complexity to the application. So by opposition by family members, for example, by requests for further information or additional steps by the PGT or the judge, involvement of Section 3 counsel, all of that can increase the cost. So it is not, it's not a process to be undertaken lightly, but sometimes it is. Sometimes it's necessary and really the only option. So that's why I always like to tell people that if the risk of not doing a power of attorney when you are capable of doing one, you may never need it, but if you do need it and you haven't made one, then the option available to you is such a significantly more onerous and difficult and expensive proceeding than simply making a power of attorney would be. So I think that's everything. That gives us a few minutes for questions.
Definitely. Thank you so much, Helen. That was such wonderful information, and that really has helped my knowledge even further increase more on understanding the difference between the role of the POA and the guardianship role and the different legalities there. So thank you so much for bringing that information to us today. And of course, for our participants, please feel free to continue putting your questions in the Q&A box. So some of that have come through are saying, how do we start the conversation? How do we begin approaching mom or dad that now is a good time to look at this, but assure them that it's not about taking away their freedom?
Yeah. So I actually had somebody do it in what I thought was a really sensitive and effective way just a few weeks ago, where the children who are attorneys under a power of attorney, so there is an existing document, are starting to have some worries about dad being a bit vulnerable. Dad's, given his credit card out a couple of times over the phone, and they're starting to be worried. So what they did was they actually asked him if he was okay if they all together booked an appointment with me. And I'm not the lawyer who prepared the power of attorney, so there was no concern about me not being able to advise dad down the road. But basically, they brought me the power of attorney. I was the sort of neutral person, and we sat down together and we talked about, what does this mean? What would it mean if my daughter started acting in that role for me? What are dad's concerns? What can I tell him about what their duties are to make sure that his needs are met? All of that stuff. And it was they were very sensitive to his, he was a bit embarrassed, I think, when we talked about some of the expenditures he'd made recently that he really realized probably weren't what he would have done if he'd been thinking about it more. But it was a really effective way to talk. I think, chatting, if there's a power of attorney, if there's a way to sort of get together and talk about it with a lawyer, that can be really helpful. Or just talking about it together with some knowledge that you have now about how it works. Or if they haven't made one, encouraging them to, if they're capable of it, get some advice for themselves. And they may feel more comfortable going and doing that privately, and knowing that the lawyer acts just for them and is only worried about their interests and is going to do what they tell them to do as long as they're capable. So it's more something that they're doing independently to provide for later on if needed.
Excellent, great advice. Thank you so much. Next question says, when it comes to the family not agreeing, that thank you for touching on a few of that with the resolution. Are you able to put in a review clause? So asking that we meet 6 months, every 12 months to review what the power of attorney has been doing.
I probably would not. I don't know that would be enforceable. I think the legislation covers you pretty well in terms of the attorney having to account for everything that they've been doing. So even if you don't, if they're not doing it on that sort of, annual or biannual basis or whatever, they are always obligated to account for their activities in that role. So if it's the incapable individual, can always say, I want to know what you've been doing. But someone on their behalf can also say that. Or ultimately, if your position is a beneficiary of the person's eventual estate, you can also express concerns. And the attorney is going to be obligated to account for their activities.
Another question has come. Does one have more power than another? If you're a POA or a guardian, does one give you more power?
So the guardian is more, I think I said more sort of the blanket. So it does, because it requires the finding of incapacity by its nature. The guardianship means if you have an order appointing you guardian, you are in that role immediately, and you're the decision maker for the individual. So there is no question about, if I make my power of attorney, I may be capable for the next 40 years, and no one can do anything that's against what I would want to do. But by its very nature, a guardianship order says that the individual is incapable, and the guardian is now the one who makes all of the decisions.
Quick question. Someone said, you mentioned a power of attorney cannot change a will. Can a guardian change a will?
Oh, no. And so usually, again, it depends on, so some situations, if the guardian is a guardian of someone who's been incapable all along, so for someone with a disability that they've had all along, for example, there never could have been a will because the person never would have had capacity to make the will. But if it's someone who had capacity before and then becomes incapable and needs a guardian, no, you can't change the will. And in fact, one of the obligations of an attorney and a guardian, again, is to find out if there is a will, figure out what's in it, and make sure you don't do anything that would make it impossible to honor the will. So if the will leaves my piano to my friend Bob, you don't get rid of the piano.
Thank you so much. Thank you, Helen.
Mary, there was just a couple of other questions for Helen. Just talking about the power of attorney kits, and if you would, are there any thoughts on the home power of attorney kits that are not completed directly by a lawyer, so not getting legal advice?
So a lot of people do them. I generally, as a rule, don't comment on documents that people have done for themselves, just because I haven't looked at an individual's document, but I know that a lot of people have used them, found them to be fine. The only thing I always caution is just take care that when you're signing and witnessing them, that they're properly witnessed. So sometimes I will see one brought to me and it's witnessed by the attorney, for example, and then it's no good. So just making sure that you're careful to read the instructions about who the witnesses can be, dating and signing properly, all of that stuff to make sure that they're going to be valid.
And then there was just, I think you've already addressed this, but maybe just a quick recap of what the differences between a guardian and a POA was similar or different.
Well, so those are big differences. So the POA is made by the individual themselves, appointing the attorney that they choose. It's made while they're capable. It's not a court process. It's just done either themselves or with a lawyer preparing the document. The guardianship is a court process to appoint someone. It involves a finding that the individual is incapable. It is lengthy, costly, involves notice to family members so others can get involved. So there are lots of big differences.
Then we just have a question about the differences. Can you speak to the differences in mental incapacity versus legal incapacity? When someone who is in hospital and there is a decision about an individual's ability to return home if there is no POA in existence?
Well, so that's again where probably you're looking at getting a capacity assessment of the person, finding out if they're capable of making a POA or making their own decisions about where they go. And if not, then if there's no POA, looking at a guardianship application, whether that's appropriate if they have been deemed to be incapable. There are criteria for, and it's developed all through case law, for what constitutes capacity to make different kinds of decisions. So the capacity to make a will is different from the capacity to make a power of attorney for property or to manage property. That's different from the capacity to make medical decisions. It's going to be sort of determined on a case-by-case basis.
Right, and not hire incapacity assessor for medical decisions, because that can be a medical professional that would make those those decisions. Okay. Mary, do you have any other questions? I have one other one.
No, go ahead, Rayanne.
Okay. One other person just asked about how do you check if there's an existing POA, but that's a pretty easy one to answer, I think.
It's well, and so unfortunately in Ontario, there is no central registry for anything like that. Some jurisdictions have that, which is very nice. In Ontario, we don't. You would probably, if it's someone that you live with or are able to look for power of attorney document at home, you could do that. If you know who their lawyer was, you can call the lawyer's office and see if there's one. But unfortunately, there's no like central repository of POAs that you can search.
Right. And I know some of the questions that we often get in our office relating to power of attorney for personal care is one that relates to long-term care or in retirement homes where the person has power of attorney for care and restricts visitors. Could you speak to that?
Well, that's another sort of case-by-case one. I mentioned that one of the obligations of an attorney for personal care is to facilitate contact of the person with supportive family members and friends. As you can imagine, the question of what's supportive, who is appropriate to see this person can be difficult and can be a source of conflict. So it may be that the attorney very rightly thinks it's appropriate to restrict visits from someone who has, been abusive in the past, or who, the person finds it upsetting to talk to. Maybe it's appropriate to restrict their visits. On the other hand, sometimes I hear from people who say, my brother won't let me see my mom and he's abusing her and is keeping people from her. So those are really difficult situations that can arise and sort of have to be taken on a case-by-case basis, because the attorney does have an obligation to protect the person, and sometimes protecting might mean restricting a visitor, but it can also be the opposite.
Thanks. And I just saw one question and was in the chat box. Does the public guardian trustee have the responsibility of ensuring their long-term care client makes a will? A person had a next of kin enter in his prison documents, but the PGT would not communicate with a next of kin, only family that showed up after he had passed away.
I don't know what the answer to that would be, or the reason for that. I'm not sure. It might be something specific to that situation. But making a will is, so if a person is capable of making a will, they likely wouldn't have a guardian. So there's no real obligation on anybody to force anybody else to make a will.
And we'll do one last question, Mary, and then we'll wrap it up.
No
when might you consider involving the police if they felt they were not acting in the best interest of an individual?
So it usually wouldn't be me doing it, but it might be me advising a client that it's time to do that. It's usually up to the client, but if a client thinks that that safety is threatened, or thinks that there's fraudulent activity going on, then the police are going to have a different ability to help than I might have, especially if there's urgency to the matter. So it may be that I often come in later. I often come in after the death of the incapable person, when someone's going, what happened with all of our assets? And then we can do the slower plotting process through the court of having them account and looking at the accounts and blah, blah, blah. If my client comes to me and says, I'm really worried that something urgently needs to be done here because safety is at risk, for example, then I'm probably going to say you need to think about calling the police.
Wonderful. Thank you so much. Rihanna, I guess that'll wrap up everything for our Q&A.
Yes.
Perfect. Thank you. A lot more questions have come through. So as you can see, Helen, always a really topic that people do have a lot of questions, comments, concerns on. Just to let you know, in our chat box, there's been so much positive feedback. Thanking you so much for your time today. Great information and really helping a lot of stakeholders and families navigate through what can sometimes be quite difficult, quite challenging, and really helping all of us today understand the differences on powers of attorneys and guardianship. So thank you so much. Really well appreciated.
Thank you.
And just as we wrap up for today, to let everybody know, of course, our Ontario Senior Safety Line, available 24 hours a day, 365 days a year, run by our partners with the Assaulted Women's Helpline. And the number, of course, is there, and through our website available also as well for support, information, and referrals. And of course, please reach out to Elder Abuse Prevention Ontario. You can reach us through social media for information and referrals, through our website. We have our Zoom platforms for webinars and information, tools and resources, and of course, customized training and education that our consultants are able to provide to stakeholders, organizations, faith groups right across the province. So feel free to reach out to us through our site. Our resources are available there as well. Most of them are available for download. So please come and visit us at the amazing, which I'm very proud of, the new Elder Abuse site with information for you at your fingertips, available anytime at www.eapon.ca, and of course through your mobile app as well. Upcoming next week, we have our webinar on April 9th, sorry, not next week, but still this week, my apologies, April 19th, April 26th, my apologies, I am getting tongue-tied here, for the Ontario Human Rights Commission with our guest speaker on understanding ageism and the rights of the older person in Ontario. That will be on April the 26th of 2022, next week. We hope you're able to join us, and you can sign up for that through our site as well. Please, again, just take a moment to fill out our evaluation. We always appreciate your feedback and comments, so thank you so much for doing that. And again, a large, big thank you to our speaker today, our guest speaker, Helen Button from Gunn & Associates. And we thank you for your time, information, and I know you'll be invited back to speak to us, I'm sure, at a later date and time. It was really well received today, so thank you so much, Helen, on behalf of the entire staff and team at Elder Abuse Prevention Ontario for your time today.
Thank you, everyone. I enjoyed it.
You're wonderful. Wishing everybody a wonderful afternoon, all the best, and we'll be in touch shortly. Take care, everybody. Thank you.